Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.
Welcome to St. Louis on the Air. I'm Sarah Fensky, in for Elaine Cha.
Every part of civil society depends on people making a choice to behave.
I don't know what was going on in his world and in his life, and I imagine that there were some dark days.
I think drugs may have been involved.
They're going to want to give her millions of dollars, but you've got a bunch of defendants in this case that you probably can't collect a whole lot from.
Janae Edmondson is suing the city of St. Louis. The Tennessee teenager alleges the city failed to properly maintain the intersection of 11th Street and St. Charles. A tragic accident led not only to both of Edmondson's legs being amputated, but the fallout also toppled St. Louis Circuit Attorney Kim Gardner. So why does Janae Edmondson's lawsuit focus not on matters of criminal justice, but infrastructure? And what about St. Louis City Councilor Sheena Hamilton? She issues legal opinions for the Board of Aldermen, but she says aldermen can't release them. They're attorney-client privilege. Does it matter if we, the people, are footing the bill? Our monthly Legal Roundtable has opinions on that and much more. And joining us today to share hers is Connie McFarland-Butler. She's a former partner at Armstrong Teasdale and now owns her own firm. That's the law office of Connie McFarland-Butler in Florissant. Connie, welcome back.
Thank you.
And we're also joined today by Bevis Schock. He is an attorney at Schock Law in Clayton. Bevis, welcome back.
Thank you, Sarah.
And last but not least, making his Legal Roundtable debut today is Jim Wyrsch. He's a former public defender. He's now in private practice as a founding partner at the law firm Wyrsch, where he specializes in civil rights litigation, and he lives in St. Louis. Jim, welcome.
Thank you for having me.
So, high-profile case in the news this past month. Janae Edmondson is suing the city. She was hit by a man, Daniel Riley, who was driving the streets of downtown at very high speeds. That's while he was awaiting trial, and he had notched multiple violations of his pretrial release conditions. The fact he was out on the streets instead of in jail is a big part of why St. Louis Circuit Attorney Kim Gardner was forced to resign. But Janae Edmondson's lawyers aren't suing Kim Gardner. They're not suing the judge who failed to order Daniel Riley back behind bars. They're suing the city, and they're suing something over premises liability. Connie, what's the heart of this case here?
Well, the heart of the case is that it is a negligence case, a personal injury case, and sovereign immunity protects public entities and governmental entities from these types of lawsuits, except for in certain circumstances. And the exception for sovereign immunity, well, there are two. There's one if there is a motor vehicle accident, and then the other is if there is a dangerous condition that is maintained by the city. So the only way that the plaintiff's attorney could get the city of St. Louis into this case was by alleging that a dangerous condition existed at that intersection, that instead of a yield sign, that there should have been some type of traffic signal, traffic light, or stop sign. So this is plaintiff's attorney's way to get another entity into the lawsuit and bring a little bit more money to the table.
So as this plays out, will that truly end up being the focus of the legal machinations, or is that a way to get in and then this still becomes about the city's political structure?
Well, I don't think. Well, of course, the political structure will play some role in it. However, the focus will be in order to keep the city in order to collect money from the city, which will be minimal because there are caps in place for public entities. So as I recall from looking at the chart, that for a single accident, that the cap is right at $488,000. And if there are multiple individuals who are injured by a single incident, then the cap is a little over 3.2 million. So there's not a whole lot, given all of the surgeries and the injuries that were sustained by this young lady. There isn't a whole lot to be collected from the city of St. Louis, even with this dangerous condition argument.
Wow. So $488,000 for somebody who is very tragically injured here. Bevis, what do you make of this?
I'll say three things. First, it's sad that the one case about a young lady in a volleyball tournament became the focus of everything when there are people dying from these kinds of problems all the time. But she's a white girl in town, and so suddenly that's what matters. That's the case that kicks it over.
I mean, in fairness, she is biracial.
Well, I shouldn't have said what her race. I retract that. My point is there are problems like this all the time, and suddenly that one became the thing, and I didn't like that at all. Second is I don't think that this dangerous condition argument is going to really go anywhere, except to the extent that the city wants to pay to be nice to her, which they might conclude is a good idea, even though, of course, that violates their fiduciary obligations to the taxpayer. And I feel terrible for the young lady. I mean, her life's dramatically harmed.
Yeah.
But the city, I don't think, is liable when a dangerous condition would be when the curve was too sharp, or the signs were down, the lights didn't work. I just don't see it here. So on this $488,000, maybe she has health insurance that won't have to be reimbursed. So perhaps the money that she gets won't go to her health care providers. We don't know that yet.
Yeah. I mean, so Bevis is saying he doesn't think they have a great case here. Jim, would you concur with that?
I don't think we have enough information at this point. I mean, if you look at the case law regarding the waiver of sovereign immunity based on this dangerous condition, it's very fact intensive.
Yeah.
They'll look at whether there were traffic studies done at that intersection, whether there was a past history at the intersection of other accidents, things to put the city on notice. So if you read the cases, they're extremely fact-intensive. So I think discovery is going to bear that out, and we don't have the information to make a determination at this point whether or not that will bear any fruit.
So it all really comes down to this intersection. Did the city know this intersection was a problem?
Right.
Less so this young man who was driving terribly. I'm assuming that's because he just doesn't have assets that are going to be that valuable for these lawyers to try to get.
I mean, I don't know his particular circumstance, but from what I understand, he probably does not. But you notice they didn't name just the city. They named him. They named the person who rented the car. They named the person who was driving the other car, and they named the company that rented the car.
Enterprise. Basically. Yeah.
And so they're going after numerous pockets.
Well, in my experience, getting the judgment is half the battle. Collecting the judgment is the other half of the battle. And I think that there are going to be significant challenges in this case. You've got a very beautiful, sympathetic young lady as the plaintiff. And I think that a jury, given all of her medical expenses and various surgeries, that they're going to want to give her millions of dollars. But you've got a bunch of defendants in this case that you probably can't collect a whole lot from. You've got the sovereign immunity caps for the city of St. Louis. You've had this young man who was driving the car, who's had multiple criminal infractions, who was on house arrest. So more likely than not, he has minimal assets. They've gone after his mother for negligent entrustment, claiming that she gave the car to him knowing that he didn't have a driver's license and that he was a reckless driver. More likely than not, she's got some insurance in place, but if it's your average insurance policy, it's a $25,000 cap. Ooh. And the insurance company will gladly tender that $25,000 and get out, and then leave mom standing. And I don't know what type of assets that she has, but if she's smart, she's going to run and file for bankruptcy.
Oh boy!
And then I don't know that there's any type of claim that can withstand a motion to dismiss against Enterprise, because unless mom was standing at the counter with Riley saying that, hey, I know you're on probation and you don't have a driver's license and you're a reckless driver, but I'm going to give you the key to this rental car as soon as we walk away from this desk. So So unless that situation happened, it's going to be very difficult to prove that Enterprise knew or should have known that this vehicle was going to end up in the hands of Daniel Riley. I believe he's under 25, and most rental car agreements prohibit anyone under the age of 25 driving the car. So I don't see Enterprise staying in this case very long.
So this is a real uphill battle for these attorneys, Bevis.
Just say one thing is that crime victims are crime victims. They are not tort victims. I mean, they are both, but just because you're a victim of crime doesn't really get compensated. The society says, too bad.
Yeah. Well, that's a note to end that one on. We've been talking about liability, the liability of the parties in this case. Let's talk about liability for judges. This happens to be a case that our guest, Bevis Schock, knows well about. This was his case. A judge in Taney County, Missouri, was sued for his work on a child custody case. The mom in this case, Cammie Ballard, had sued to get custody of her kids after a divorce. Well, the kids wanted to live with dad. And when they heard she was getting custody for a month, they loudly complained. Judge Eric Amy personally took the kids to a jail cell and went so far as to hold them there for an hour before letting them go. That wasn't all. Months later, the mom filed a contempt motion that prompted Judge Amy to schedule another hearing. Well, neither the dad nor the kids showed up. So Judge Amy issued a writ of bodily attachment for the dad, a pickup order for the children. Police officers in Louisiana, where they were, came to their door, gave the children Miranda warnings, placed them both in solitary confinement in a juvenile detention center. Bevis, this case is pretty insane.
One of the interesting things about it is the two plaintiffs, the kids, are actually stars. They have been on America's Got Talent. They're magicians. They've performed endlessly at Dolly Parton's place in Pigeon, Tennessee, in front of large groups of people. One got a gig in Italy in a major motion picture. She played the daughter of the star or something and had significant stuff. So they go to school under the Hollywood arrangements where they get tutors and things like that. So
you have some great clients, Bevis.
That adds a little wrinkle to the thing that makes it interesting. So let's talk about immunity. The idea of immunity for a judge is that if the judge is worried that he or she will be second-guessed by getting sued for an opinion, the judge won't be able to do the job of dispassionately looking at the facts and looking at the law and making a fair decision. So the test then becomes, was the act done by the judge, which is in controversy in the case, a judicial act? Sort of, there's something about when the judge is sitting on the bench and issuing a ruling, even a crazy ruling, crazy bad rulings are considered immune. But when they step into the lobby after court's over, robes off, and say, "Oh, you don't want to go with mom, kids? I'll show you," and march them down to the jail and put them in the hoosegow for an hour, that is not judging. And so we won that case in what's called the district court, which is the federal system trial court. Mm-hmm. And the defendants, represented by the state of Missouri Attorney General, decided the next thing was to take an appeal before the case went any further, which they're allowed to do under immunity rules. And we heard the case up in Kansas City, and I think it was in Kansas City, doesn't matter. And the judges ruled a week or so ago that there's no immunity for Judge Amy. And he's a controversial guy down in Taney County. But what's interesting is that's one of the counties where they elect the judges. So around St. Louis, they get appointed.
The Missouri Compromise.
Missouri Plan, it's
That's
called.
what I meant to say.
Missouri Compromise.
Going back Civil War on y'all.
That's 1820.
I needed that lecture, so thank you, Bevis.
Also keep in mind the Missouri Constitution, Missouri came in 1820, and the first Constitution said no black people can move to our state, which was rejected by the Congress. So we didn't actually become a state with a Constitution until 1821. Setting that aside, a judge cannot walk into the lobby, put the kids in jail, and that's what we have established so far in this matter.
Well, it seems like this is a nice precedent here. Jim, do you think the appeals court got this right?
Well, Bevis won, so yes, of course. No, but I think it's from what I understand, and correct me if I'm wrong, because they actually ruled in favor of the judge on one of the
Yeah,
issues.
we didn't win the Louisiana thing because he issued an order from the bench because the kids weren't there. Now, there's more to the story, but I'll set all that aside. The issue was he sat on the bench, issued an order to pick up the kids. That's judging.
Okay. So that he is immune for.
Correct.
But everything else, this case can proceed.
Yeah. Immune means you can't sue him. That's what immunity means. You can't sue him.
So do you think you can get a lot of money out of this guy for your clients?
Well, the Attorney General is handling the case. So they're not really playing with their own money. It's not like an insurance company that has stockholders to worry about. I don't think the Attorney General is going to want this case to go on because it makes the judicial system look bad. The judge he looks terrible. So usually the system likes to cover up its errors. Of course, that just makes us increase our demand.
I love it. Connie, it's shocking to me that a judge would do this. And it's frankly also shocking to me that the state of Missouri would defend this to the point of appealing this part of this. Are you surprised that we would see such a vigorous defense for something that seems beyond the pale to a layman?
Well, I think it is a bit egregious and a bit excessive when you have children involved to have them handcuffed and have them detained because they don't want to go with mom. However, I'm not surprised that the Attorney General is vigorously defending this action. So
that's their job.
That's their job.
Well, we'll have to get an update on this as this case continues, see how much Bevis can get as a settlement for these young magicians. We're talking today to our Legal Roundtable. That is Connie McFarland-Butler. We're also joined by Bevis Schock and Jim Wyrsch. We need to take a quick break. When we come back, we'll talk about the city's attempts to claw back $300,000 awarded to a police officer who accused the Department of Racial Discrimination. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.
Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha. This is our monthly Legal Roundtable. And this month, we're joined by Bevis Schock, who's an attorney at Schock Law in Clayton. We're also joined by Jim Wyrsch, a partner at the Wyrsch firm in St. Louis, and Connie McFarland-Butler of the law office of Connie McFarland-Butler in Florissant. Now, in March, a jury awarded former St. Louis Police Sergeant Heather Taylor $300,000. She had sued, saying she was discriminated against after speaking to the media. She says she was disciplined for speaking out, but white officers who did the same thing were not. Well, the jury found in her favor. Now the city is trying to come after that money. Their gambit involves 400 audio recordings that it turns out Heather Taylor had in her possession. And the city says these were relevant to Taylor's case, that she should have turned them over. They filed a motion asking the judge to reverse the verdict. Now, she voluntarily provided these in a different case that just so happens to be handled by Jim Wyrsch, an attorney here on this panel today. So, Jim, these tapes, these were just conversations that she had that apparently the city is saying were relevant to this case. Is that a fair summary?
Well, that's a fair summary of what the city claims. But when it got down to it, after she produced the documents that were relevant to our case to us, and then we turned around and asked the city why they didn't produce those to us in discovery, their response was to then go after her, not own up to its own discovery errors. But then even though there's this notion of 400 recordings, if you read the judge's opinion, it really got down to about 5 that the city claimed were arguably relevant to their case. And then the judge analyzed those 5 and found that maybe a couple were potentially responsive to the request. And so of the 400, I don't know what was on those, but very few of them seem to have been anywhere related to the lawsuit she filed. Okay. So this seems like much ado about nothing by the city.
But some of them may have been relevant. Connie, what did the judge just ruled on this, I believe, 2 days ago?
Yes.
What's the heart of her ruling here?
Well, the judge indicated that the recordings that they may have been responsive to some of the discovery that was requested in the case. The city councilor's office filed their motion for new trial, motion to set aside the $300,000 verdict that was entered by the jury back in March, and they claimed that these recordings were relevant, and that if the jury was able to actually hear the conversations and the context of the conversations and the tone of the voices and so forth, that they may have had a different interpretation. Rather than simply Sergeant Taylor indicating or summarizing what the conversations were about. I agree that the judge kind of whittled it down to the 5 audios of the 400, and the judge indicated that some of what was produced may have been responsive to discovery request. But I find it just very difficult as someone who's practiced, civil litigation since graduating from law school. Standard civil discovery interrogatories and requests for productions, you always ask for any statements of any kind, whether it's written or auditory, of statements that were given by employees of an entity. And Sheena Hamilton, I worked with her at Armstrong Teasdale. She's very sharp. She's a pit bull. I find it very difficult to believe that office did not issue interrogatories or requests for production asking for statements by any of the city's employees. Nonetheless, the judge said that the audios may have been responsive to some of the requests that were issued by the city, but the judge went on to say that the production of the documents would not have swayed the jury, which I found very interesting, that the judge took the position that, okay, yeah, you did produce this and it may have been relevant and it may have been responsive, but it wasn't going to change the jury's mind anyway. So keep that $300,000. And by the way, let me give you $326,000 for your attorney's fees too.
Yeah. So you think this is, I see some skepticism towards some of these conclusions that were reached here. Bevis, do you share some of that skepticism?
If I were sitting on the bench and I found out that plaintiff had withheld those conversations, I would declare the case over, dismiss her claim, and say, you get nothing. That's what I would have done.
Wow.
And I think we'll get an appeal on this for sure. It's sort of interesting that he actually has finished his ruling, or his or her ruling. I don't know who the judge is.
She.
Her. Yeah. But because usually in something like this, the judge will throw out the idea that there's a problem, which then gets the parties to reach a quick settlement.
And she didn't do that, the judge.
Didn't do that. That's unusual to me.
So, Jim, you've had some indirect role in this. What would you say in response to what Connie and Bevis are saying here, that this is a bigger deal maybe than the judge made it out to be?
Well, I would say that, as a civil attorney, we certainly take our discovery duties very seriously. I would note that we've had plenty of discovery disputes with the city itself, so there's a little bit of a curious eye that I give to their positions here. But ultimately, if you read the judge's ruling, it wasn't just whether or not they were, responsive to the request. She looked at them and she said, frankly, a lot of them didn't relate to anything in the case. So they're just irrelevant. And then a couple of them actually she said supported plaintiff's claim. So even though the city was saying that these are, would help their case, she actually said, no, it would have actually hurt your case. So it wouldn't have changed the jury's verdict. There is no prejudice. And so under those circumstances, people do make mistakes. People do not disclose things they forget about or haven't,
400 of them
overlooked. Well, 400 wasn't. They weren't relevant at all to this case. I don't know what they were about, but obviously the city of all those 400 got down to 5. They said was arguably relevant, and the judge disagreed with them on the 5. So I think that the city huffed and puffed, and it turned out that there was really nothing there, and the judge made the correct decision in my mind to look past that, see if there was prejudice, and affirm the verdict. And we'll see what happens on appeal.
Bevis.
How many people record 400 conversations? What about that part?
I feel like increasingly people are doing this, and it's almost a little unnerving. Young people are just rolling tape on their phones all the time these days.
Is there a button on the iPhone where a person can record the conversation they're having?
Yes. Easily.
Yeah. And I think that's what people are doing. So
just swipe down, and there's a little record button right there.
So you really
takes 5 seconds.
shouldn't say anything in private that you wouldn't say on the radio, Bevis, but still covers a wide gamut there.
I'm going to walk on the beach.
So, Connie, you had mentioned Sheena Hamilton, who's the city councilor who was pursuing this appeal on behalf of the city. She's a pit bull. She is starting to attract some attention. The media is kind of paying attention to. She's very aggressively fighting on behalf of the city, which is her job.
That's her job, and that's her personality.
Yeah. So one of these cases that has drawn now, I believe, 2 columns from Tony Messenger involves attorney-client privilege. And this is City Councilor Sheena Hamilton has weighed in on a board bill by Alderwoman Kara Spencer. This bill would allow the city to crack down on people openly carrying firearms, basically say you have to have a permit to do that. And this would make it much harder, if it was constitutional, if it could pass muster, for teens to wander around downtown toting firearms, which we know they tend to do here. So in this legal opinion, the city councilor, Sheena Hamilton, opined that this bill could well pass constitutional muster. But we apparently are not supposed to see that opinion. In a new policy, the city councilor's office says that such opinions are subject to attorney-client privilege, and that means that aldermen can't share them with the public. Jim, do you think that's a fair interpretation of state law and of the laws on privilege?
Well, I think on the one hand, the notion that the city councilor can produce privileged opinions is certainly valid. I mean, we have exceptions in the open records laws and to allow city lawyers to give open advice to their clients. What gets kind of sticky here is who is the client? And typically in our business, when we have a client, the person who is allowed to waive privilege is the client. Not the lawyer can't control that. And so here, where you have a municipal entity and you've got multiple people, I mean, the city councilor is advising the mayor, advising the board of aldermen, doing all sorts of things. You have there's sticky questions about who is the client, who can waive that privilege, and I would contend that the board of aldermen who requested the opinion have every right to release the opinion since they are essentially the client in that transaction. And it's arguable also whether or not in this specific instance there is a privilege at all. I mean, the courts are really kind of murky on whether or not advice given to an assembly or legislature when that can become privilege and who can waive that. So I think there's a lot of interesting issues here that need to be looked at.
Bevis, what do you make of this one?
Well, I just agree with Jim completely. The question is who has the right to waive it. I don't think the attorney ever could be the one to say it's privilege. Maybe there's a way around it. I don't know.
So the client is really in the driver's seat as far as determining whether they can share advice from their lawyer, whether they could share an opinion from their lawyer. That's just generally how it works.
Right.
Well, she can of course assert the objection and say that it's protected by attorney-client privilege, and then someone has to challenge it, or the client has to say, hey, I waive it.
Yeah. She wrote in this opinion saying, please don't share this. I want this to be privileged. Quote, in my view, sharing this advice could open the city to legal risk. Do you see legal risk here with this now being disseminated? Tony Messenger got this opinion despite her requesting that people not give it to him.
Well, I'm not quite sure what risk there would be with it being disseminated. Maybe they wanted to keep all the horses in the barn for as long as they could before this legislation made it to the floor.
Yeah. It's interesting. This does come down, the focus of this is this bill that has become somewhat controversial at City Hall. There's a lot of discussions over this bill by Kara Spencer that would try to crack down on open carry. Jim, do you think the city councilor got this right, that this is a bill that could actually stand up in a court of law?
Yeah, I think the opinion that she gave, and I think there were parts of the original bill that there were some questions about, but ultimately it's it could hold up. I mean, of course, we're living in a state where the state has made it very clear that they don't want to restrict guns in any way. And so I could very well see a court rejecting that based on preemption grounds by the state government. But from a constitutional perspective, it probably passes muster.
Bevis is a libertarian. I wonder if you have a different take on that.
I like everybody to have open carry 100% of the time. And if, in fact, they pass this, the state legislature will immediately pass a law saying that ordinance is invalid. So that'll be the end of that.
Maybe we get 6 months of it before they go back into session. And then, Would you take this case, challenging this?
I don't know. I would actually look pretty seriously at that. Yeah, but I haven't really studied what the statutes say about open carry. And of course, let's be honest. Every part of civil society depends on people making a choice to behave. I mean, the only way we can live together as people is to act in a reasonably moral manner for each other. The constant barrage of murder headlines would indicate that a lot of people are not following that. So then we come to, I want to carry a gun in case the other guy has a gun, and I can defend my life, my unalienable right to my life by protecting my life with my gun against the bad guy who has a gun. I mean, this argument is nothing new.
Right.
This is what's discussed every day in the gun wars. But I really do believe that open carry is a really good thing. It makes people very courteous to each other.
Well, this is an opinion you might not always hear on public radio, so we're glad to present it today. I have a feeling my other two panelists would disagree with that, but I'm not going to put them on the spot because this is a show about the law, not necessarily that we're talking politics. Interesting to see how this one is going to play out, and interesting to see if the Board of Aldermen will feel empowered now to say, oh, yes, I am going to waive this attorney-client privilege. I'm sharing this opinion with you, the media. Next up, we'll talk about a big change to how judges in Missouri think about child custody cases. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.
Welcome back. I'm Sarah Fensky. I'm here hosting the monthly Legal Roundtable on St. Louis on the Air. And today, that includes civil rights lawyer Jim Wyrsch of Kazali Wyrsch, Connie McFarland-Butler of the Law Office of Connie McFarland-Butler in Florissant, and Bevis Schock of Schock Law. Now, changes are coming to how child custody cases are handled in Missouri. Governor Mike Parson is likely to sign a bill into law that establishes 50-50 shared parenting time as the standard in child custody cases. Under Missouri law, judges now decide custody cases by weighing the best interests of the child, and the idea is that each parent should have, quote, significant, though not necessarily equal, time with the child. Contact should be, again, this is a quote, frequent, continued, and meaningful. Now, this legislation changes that. It requires judges to begin each child custody case with the presumption that equal or approximately equal parenting time for each parent is in the child's best interest. A parent would need to rebut that presumption if they want more time. Connie, you do some family law cases. How big a change would this be?
Well, frankly, I don't think it's that big of a change. I mean, at this point, judges start from the presumption that joint physical custody is presumed to be in the best interest of all children. I would say that most of the judges that, I deal with in St. Louis County, St. Louis City, that if there is a parent who asserts that they want a 50-50 schedule, then they start with the presumption that that is in the best interest of the child. And then the other parent has to rebut that and say that no, a 50-50 schedule isn't in the best interest of the child. Mm-hmm. So I don't think that we're doing anything that drastic or that different. The parent does have the right to rebut that presumption. presumption, so it'll be up to the other parent to demonstrate to the court. Usually when 50-50 schedule is an issue, typically the other parent will assert that maybe the parent who wants 50-50 doesn't have the appropriate accommodation. So you got a 2-bedroom house, but you got 10 kids. Where are all these kids going to go? Or a lot of times you'll have parents who are requesting a 50-50 schedule, but mom or dad works at night. So who's actually going to be providing care to these children while they are out of school? With grandma or babysitter over the course of the evening. So I don't think it's going to be that big of a change. I think that it's great. I think that you have a lot of fathers who, it's definitely a different generation of fathers than back when I grew up. So I think that it's a great thing that, 50-50 for all kids. Sounds good to me.
Bevis, you seem to have more misgivings about this.
Well, the first thing is that in the family law area, usually the parents despise each other, and that is your opening start. And otherwise, they wouldn't be getting divorced. And so now we're going to have this part of these cases in which each side is hammering on the judge to give their soon-to-be ex-spouse less time. Maybe that's going on all the time now. I mean, it's just such a tough area of the law. I mean, people who do it, Connie, you deserve so much credit in the system to try to help people through their problems. The old theory was that a kid should have a home. One of the parents' houses should be that child's home where they can store their little toys and trinkets and whatever. And this 50-50 would be where that wouldn't be anymore. And I don't know if that's right or wrong. I just don't have an opinion. But I should certainly say it's a change in thinking from a sociology point of view.
Bevis, you'd mentioned earlier that you got out of doing child custody cases for a real reason. What is it that steered you away from that part of the law?
Well, everybody's so unhappy the whole time. The attorneys, in my experience in the St. Louis area, who are in family law don't like each other. They all think they're hiding information, and some of them are, I imagine. But it's an area where there's so much unhappiness. Now, there used to be this judge in the city named Tom Farley. He sat on that family law bench for 15 years or something and did them all in the city. And everybody so respected him that I think it went all right. But it's a tough area.
It's interesting that this would be more contentious than some of these other big issues that people are dealing with.
I would say I would agree with Bevis that it can be contentious between the parties. The family law attorneys that I deal with, for the most part, there's just like a select group of us, and we all know each other, and we have respect for one another. It is very emotional. I mean, everyone is emotional. You're going through a divorce. You're dividing up the children. You're dividing up the assets. There aren't a whole lot of attorneys who do this, and the ones who do it don't do it for a long time, because you can burn out very easily with family law cases, because, like I said, everyone is so emotional. And, it never fails. There isn't a Thanksgiving, there isn't a Christmas that there isn't some client who's calling me because they don't know how to read the parenting plan, and they're not sure who's supposed to be dropping off little Timmy and picking him up at what time. So,
oh, wow. Well, Bevis is right. You are doing God's work here. So thank you, Connie. Now, we've talked about judges behaving badly today, putting these poor kids in solitary confinement. Let's talk about lawyers behaving badly, basically pretending to be judges. I should say, this is just one lawyer. Kind of a shocking case. This is a lawyer in Kirkwood. His name was Andrew Gavin Wynn. He apparently falsified dozens of court documents. This affected up to 30 clients. He's now going to do 2 years and 7 months in prison. There was a quote in the Post-Dispatch story about this. I don't think there's ever going to be a case quite like this one. This is from the assistant U.S. attorney who prosecuted this case. Jim, have you ever heard of anybody going to this extent to falsify documents on clients?
No, and I sure hope there's no case like that ever again. I mean, I don't know what was going on in his world and in his life, and I imagine that there were some dark days.
I think drugs may have been involved.
Yeah, and it's you step back and it's a wonder that someone could spend that much time creating false documents instead of just doing the things he's supposed to be doing. But
do the work,
right? But I don't know. I mean, he must have felt like he was against a wall and made some really poor decisions, which didn't just reflect on him, but on his firm, on the other people he worked with, and they had to clean up that mess afterwards. I mean, there were so many files and things that, clients. I mean, the effect of all this was that the clients were being told that they had. I think some of them were custody issues or something's
divorce decrees,
They
child
were
custody,
divorced,
parenting plans.
And turns out actually you're not divorced. I mean, that's
1 year later you're not divorced.
As a client, I can't imagine as a client getting that news, thinking that this thing's been resolved. Actually, no, it was all made up in a lawyer's, fugue.
I guess what I don't understand is how this wouldn't have been caught sooner, because let's take a divorce, for example. There's an opposing counsel. Wouldn't somebody have said, hey, there's no order from a judge saying this. You're not allowed to take my child away. Shouldn't this have been easier to unravel?
Well, that presumes that something was ever filed.
Yeah.
So he may never have filed anything. He may have just taken the client's money and led them on and then produced this phony divorce decree or phony parenting plan, but nothing had actually been filed with the court. I would say that, some of my clients are savvy and they know about Missouri CaseNet and they go and check and double check, or they, click on that link where they get a notification every time I file something. But most of my clients don't do that. And so the client was just kind of sitting there in the dark and trusted the attorney. And it's very shocking and it's appalling. And unfortunately, this attorney did a disservice to our profession.
Yeah, it's hard to argue with that. This is a guy that makes all of you look bad, Bevis.
I just say that something like this always starts small. I mean, he probably needed a continuance one day, and he just sort of worked up a continuance order and wrote it and filed it or something, and the other attorney said, okay, and the judge never really noticed it. The judge had 30 cases on the docket, and I don't remember that. Who cares? And then it just grows and grows and grows, and that's what happened to this guy. And I feel no sympathy at all for that person. Zero. In fact, I think his time is too short.
You think he should have done more than 2 years?
Absolutely. What a horrible thing. We are responsible as attorneys for a lot of problem solving, and we have rules, and we got to do it the right way as best we can. And we all make mistakes. Sure, you call the other attorney, I made a mistake, whatever, okay, fine. But this guy was a flagrant, deceptive, evil person.
Well, this guy is lucky that Bevis was not his judge. Here's another case. A St. Louis police detective suing the city for gender discrimination. She says she was arguing with a female colleague when her supervisor told her, quote, if you're going to fight, take your clothes off. When she complained, she says that same supervisor then retaliated against her. So this really kind of boils down to one comment. Connie, based on that, could she have a case for gender discrimination?
I think that one comment is not sufficient. Now, if there had been a history of making these types of comments, then, maybe there's an argument that, it's a toxic work environment or sexual harassment. But I think the comment in and of itself was not that vulgar. Was it inappropriate? Was it something that shouldn't have been said? Of course not. It shouldn't have. But does it rise to the level that I think a jury would award money, enter a verdict on behalf of the department for that one comment? I think not.
What about the retaliation case here? It does seem pretty clear that she did complain about this comment, and then, boy, did her work schedule end up getting kind of tricky. Could this be a case where she can win on retaliation, even if there wasn't the core discrimination?
Yeah, I mean, it certainly is troubling when you see that people are taking these things, getting a complaint, and instead of just dealing with the complaint, going and making that person's life more difficult in various ways. And so those are very troubling allegations, and that could be a stronger case than just the one comment by itself.
Bevis, I was somewhat surprised that she sued under gender discrimination and not sexual harassment. It just feels like this is the kind of comment that you see filed under that. Any thoughts on that?
I don't really know what the theory was on that. The main thing that I agree with Connie on is that one comment, I mean, a person can even use the N-word one time, and there's a case that says one time, not
Really?
compensable. Absolutely.
Wow.
Single comments, just one event, will not get home on a hostile work environment claim. And so I was...
Wow, I'm shocked by that case law, because that feels like just the definition of you have just created such a hostile workplace for that employee.
Absolutely, but there's an Eighth Circuit case, which is our federal court appeals area around here, that says that. So.
Well, this person may have a tough road on this case. Let's talk about the St. Louis Circuit Attorney's Office. This has been such a topic on this show in the past year. Just many of the issues that Circuit Attorney Kim Gardner was having. And then, as we met last month, she had very recently resigned. It had been an accelerated resignation on her part. I believe her last day was originally meant to be at the end of the month, not in the middle of the month. So now we have Gabriel Gore is our new St. Louis Circuit Attorney. Jim, is he off to a good start?
I believe so. And I worked with Gabe at a law firm together a few years ago, and I think he's an excellent attorney and an excellent person. I think it's too early to tell exactly what's happened, but I think he's made a lot of good decisions in bringing back a lot of familiar names. I mean, as a public defender in the past, we're seeing a lot of the same people who used to be in the office under Jennifer Joyce, who have a lot of experience, who can try a case, who are going to be responsive and show up for court.
That's important.
I mean, it's unfortunate that we have to do
Essential.
It's unfortunate that the bare minimum is the standard now. But no, I have confidence as a city resident and a lawyer that he's bringing in some good people with some good experience who will help right this ship. And I think that's what his job is to do, is to just staff it up and train people who need training. But to the extent that you can get some of that old guard who had tried hundreds of cases, that's going to really improve the office right away.
It was interesting to see some U.S. attorneys. They've agreed to sort of loan themselves to the office. They're not coming over to work full time, but they are handling some cases just to get some of these murders off the books. It seems like something that maybe could or should have happened months ago with all of this backup that we're having. Nevertheless, probably a good development that we're seeing now.
No, I certainly agree that Gabe is a great guy. He's an excellent attorney. I think he was a good choice. He's doing all the necessary things to staff the office, beef the office up, get the experienced attorneys back into the office. I think it's a great idea to work with the U.S. Attorney's Office. I know that at one point they were reaching out to St. Louis County, trying to do a partnership with their Circuit Attorney's Office. I think at this point it's all hands on deck. Anyone who can assist to right the ship and get things going in the right direction, you need to take that help. My guess is that help probably wasn't accepted a while back because Kim Gardner was in the thick of things, and then accepting that help might make it look like that, maybe she wasn't doing her job. So that's probably why the help wasn't accepted back then, or there may have been those who didn't offer the help because they didn't want to jump on a sinking ship. So, but I think they're off to a great start. The mere fact that things are quiet and that you're not hearing some story about the circuit attorney every day and every time you turn on the television, I think that is absolutely amazing. In the past, you only heard about the circuit attorneys when there's some major criminal case that was going to trial or some type of arrest. So I think that quiet is good.
Yeah. As journalists, I feel like the week after Gardner finally left office, we're like, wow, what are we going to do all day? Like, it was just this strange moment of quiet. It is nice to see things going back to normal. Speaking of Kim Gardner, in the past month, she got summoned for jury duty. She barely manages to get out of that office, and they're pulling her right back in for the princely sum of $12 a day. She did show up, did her service there. She was not chosen for a jury because every single case that could have gone to trial that day got settled. Bevis, would you want Kim Gardner on your jury?
No. And there's the problem with something like that is that it becomes a circus. What you want from your jurors is just regular people who are going to go back in the deliberation room and work it out. And when someone like that, I mean, I think Barack Obama was summoned for jury duty in Chicago after he was president. It's just silly. And it what it does is it takes away from this detachment that the jury needs to have.
Because her voice would just end up, people would want to ask her about things, whether or not
there'd be all these press people trying to, she smiled when the witness said this. I mean, just get out of here.
We would totally do that. Speaking on behalf of the press, yes, we would enjoy that. Jim, would you want her on your jury?
Oh, I mean, nothing personal against her, but for some of the same reasons Bevis said, and generally I don't like lawyers in my jury. But I think anytime, like Bevis is saying, you have someone who's beyond the pale. I mean, we just need some folks who are going to decide the case and not get the focus on them, put the focus on the case.
Yeah, that totally makes sense. Connie, I'm going to give you a quick yes or no. You want Kim Gardner on your jury?
Depends on the circumstances.
Yeah.
I frankly think the timing of when she was called for jury duty is interesting, and if someone had a warped personality or
maybe not so random,
was being facetious about calling her back for jury duty 2 weeks after she quit her job and left the courthouse. So, but more likely than not, she would never make it onto anyone's panel.
I think that's a fair summary there. Connie McFarland-Butler, thank you so much for joining us today.
You're welcome. Thank you.
And also Jim Wyrsch, thank you.
Thank you.
And Bevis Schock, thank you.
Thanks for having me.
This episode was produced by Alex Hoyer and Sarah Fensky,
with audio engineering and podcast design by Aaron Dorr.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
St. Louis on the Air proudly supports local artists by using music from Life Creative Group.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
Support comes from the Missouri Forest Products Association, committed to conservation and careful management of the state's forests to make them more resilient and better habitats for wildlife. ChooseWood.com.